Welcome, everybody. So excited to have you in class today. Today's class is going to look closely at civil liberties, trying to understand the ideas behind civil liberties and their meaning from the founding generation till today. Now, my name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and we're so excited to have you all in class today. Today, we're going to walk through these stories, the court cases, and the amendments with one of our top scholars at the National Constitution Center, Nick Mosvick. Nick, you want to say hi to everybody?
Hi, and we have somebody who says they don't have audio, so we just better double check that. I'm not sure what that means.
Janet, I'll chat you up in the chat to make sure it works for you, but make sure you hit that plus volume.
I just want to make sure there's not more than one person who isn't hearing things.
Yep, Laura, you can hear us.
Okay.
It's all good for us. Thank you, Lauren.
I just want to keep talking if all you see is my lips moving.
Okay, so Nick, before we even get into this, I know we've talked about the fact that we hear the word civil liberties all the time, but we want to start with a clean definition. So give us an idea for all the students, when they hear civil liberties, what are people really talking about?
Yeah, so I think the good place to start is one with the text as we have here, right? Okay, so civil liberties, we're basically talking about, essential freedoms, essential rights that are guaranteed to individuals against arbitrary actions. And by that, we mean governmental actions, right? When we're talking civil liberties, we're talking about protections against government action without due process of law. And those things kind of go together. Arbitrary action typically means something done without process. To be arbitrary is to be at the will of another. So as we often talk about with rule of law, when we talk about that, the whole concept is that it's not at the will of one person who can pick how to choose, how to punish different people different ways or which rights to protect at different times, but it's according to the law, right, and to a guarantee of rights. Hence that language is doing that work, right? It's a guarantee against this right means different things depending on who enforces it. No, it means this specific thing for all time in some sense, right?
Got it. So it starts with we have basic rights and freedoms, and we are also guaranteed that we will be treated in a fair, equal, and just way. Is that kind of an easy way to summarize it?
Yeah, and I think that way we can connect it to the other stuff we talk about all the time, right? So you can.
Yeah, absolutely. So when we started kind of thinking of questions around this, is what are some of the constitutional protections that individual rights have in our government? So where in the law, where in the Constitution are these rights? And we came up with a big list of ideas that we're going to cover in class. We're going to look at the courts and their role in protecting civil liberties. We're going to look at like a base key civil liberty, which is freedom of speech, freedom of religion. We'll talk about due process. That's making sure that there's a process that we follow that's fair to everybody. We'll look at privacy. We'll look at equal protection, my favorite word, incorporation, and Nick's favorite from the beginning, habeas corpus. So some of the big ideas that we'll go through today. But when we think about this, Nick, and we think about kind of the beginning and where this comes from, so many people look at the words of the Declaration of Independence and say, okay, Declaration of Independence lays this out. But then can you kind of walk us through what's the big idea here? And then where did we get these ideas from when they were beginning to write the Declaration?
Yeah, so I think the really important thing here is to realize that the founding generation, the 18th century, wouldn't have understood the words civil liberties. So civil liberties is kind of a relatively modern term, what historians would call an anachronism, which is to say that that's not, again, in the 18th century, they wouldn't have really recognized that. They would have used different language. So when we talk about the Declaration of Independence, we talk about certain unalienable rights, life, liberty, and the pursuits of happiness. We're generally speaking about natural rights. Natural liberty is the basis, and what they would have called the fundamental rights of Englishmen. And don't let that word throw you. Englishmen is just a way of saying English citizens, that they were people under the British crown or the British authority, right, within the British Empire, right? And the claim that as a result of being a citizen of the empire, you had certain guaranteed fundamental rights. And those fundamental rights went back to the Magna Carta. They included things like we've already mentioned, due process. Yes, habeas corpus was one of the ancient writs of liberty is what they would have called them. Freedom of speech is we talk about in that class. That's something that kind of evolves over time. That's really kind of an Enlightenment concept. Freedom of religion is actually a fairly American concept, which is precisely why the religious dissidents came to the North American shores in the first place. But due process, yes, that's very much in the Magna Carta. That's an old term. And due process is kind of the base idea for which these other criminal protections, these criminal liberties that we give to the defendants evolve out of, right? Things like you might recognize like the Eighth Amendment against the prohibition against cruel and unusual punishments, which we see by the 17th century in England within their Bill of Rights. But that flows from the idea of process, and that there are certain liberties that have to be guaranteed in any criminal trial against a citizen. In other words, that goes back to that arbitrary concept, right? You can't just arrest, imprison, and punish somebody without telling them why, and not only asserting a reason for doing so, but then if it's a criminal trial, you have a jury trial right? You have a right to be tried before members of your community, right? Those are all part of process. And so I'm just trying to get that big picture by which these core fundamental rights flow. And it's those kinds of things that the framers are thinking about, right? So they have the natural rights referred to in the Declaration of Independence, and then these fundamental rights of English liberty that I just mentioned, all these kind of ancient liberties that eventually you see in the Bill of Rights, and then of course the state constitutions as well. All those kind of come together over time and eventually become part of what we call civil liberties. So there's this flow and change over time that I think students need to understand. And really, we're talking about over 800 years of thinking about what essentially we're talking about these fundamental rights or liberties.
Oh, and I think that's fascinating. And so not only does almost the world of like rights start to change. So he says 800 years because he's looking at the Magna Carta 1215. But you're building on this thing that you must be treated fairly. You must be treated in a way that's clear, that everybody sees and it's applied equally. You must, for due process of the law, you have to go through a process, and you're going to trust the process if it's clear, if you're given a reason why, if you're tried by your peers. So all these things set up a legitimate system of laws that we see as a way to protect the liberty of the people, that it's in there, that we have a just and fair system for all, that's clear, that's transparent, that protects all of us. But you're right, over 800 years this is spelled out. But I also love that, like, almost the words, they start with the idea of natural rights, that's why you have it. But now we have like these new words in our vocabulary that really spell out civil liberties. So students, if you're looking at primary source documents from the 1700s and 1800s and you search for civil liberties in there, you won't find it in there. Doesn't mean the concept's not in there, but the word wasn't used at that time. So that's a really cool thing to look at, Nick.
Although Nick, you may find it in the end of the 19th century, because I will say from experience that in the Civil War, you do start to see a change in the language used in terms of referencing what we call civil liberties, which is to say, the reason they did that is precisely because the things we're talking about, some opponents of the Lincoln administration felt were being unconstitutionally deprived, which included shutting down newspapers, so freedom of speech, suspension of the writ of habeas corpus, things like that, right? Violation of due process, the Sixth Amendment, trial by jury, because if a military court tries you, it's not court of your citizens, all those kinds of things, right? So their complaints was, this is all in one package. What is that package? Well, you violated our civil liberties. So in other words, it kind of required a crisis to imagine a way of taking those Bill of Rights and saying, hey, you violated a whole bunch of things. We call that our civil liberties being violated as well. So it's a change over time, but really it is the 20th century where we really think systematically about, we have these civil liberties, these protections against government. Here are what they are. Now we're going to define these one by one. The Supreme Court starts doing that. So part of the difference too is in the Civil War, the Supreme Court isn't actively defining civil liberties. So if you do a search, you're not going to find much, partly because there isn't this big conversation about what they are. That also takes time to evolve.
And I love the idea that we begin with liberty, and then we start adding these kind of categories like our civil, our personal, our human liberties. And these are really first spelled out in the Bill of Rights. So do you want to kind of really quickly walk us through the Bill of Rights? And then we'll jump to the Civil War and like what changes everything in the Civil War that makes these rights apply to everybody and not just holding back what the founding generation was scared of, a big giant federal government squishing in liberties. Now it changes after the Civil War. So walk us through the Bill of Rights, kind of what's in there as examples of civil liberties, and then we'll jump into 14th Amendment, Reconstruction, Civil War, and incorporation.
Yeah, and I'll just say, because I think it's worth mentioning, that there are some Federalist founders like Alexander Hamilton, if you read the Federalist Papers, whose whole idea is don't complain about needing a Bill of Rights, anti-Federalist opponents of the Constitution, because the best guarantee of those fundamental liberties you keep talking about is a strong central government that can actually enforce the rights, whether it be the judiciary or the forces of that national government. That's what you need to actually enforce those rights. So that's actually the Hamiltonian proposition, is you don't even need a Bill of Rights necessarily, because the whole point of forming this better union is it will actually do the job of protecting those fundamental liberties you're talking about, right? So, but we do get a Bill of Rights because they do complain enough. Madison does give them one. Hamilton doesn't support it, obviously, but we do end up with one. Initially, that push was actually, as we talk about in our Bill of Rights, for greater limitations on the national government. That's what the anti-federalists really wanted. They didn't really want, give us a couple of the essential protections, because they thought there was more than that anyways. But the original concept too was that the states would do a better job of protecting those essential freedoms. The Civil War, what does that teach us? Well, it teaches a lot of people, at least those who are drafting the 14th Amendment, that the state governments can't necessarily be trusted. So, I mean, that's not just the war itself, that's Reconstruction, that's the Black Codes, that it's the state governments now who are passing limitations on Black freedom in a whole variety of ways, from property rights and contract rights, self-defense, and restrictions that had gone back to before the war, which included on religious liberty, the meetings of Black churches, of abolitionist newspapers and meetings, being on a jury, that there was restrictions on Black jurors. We call like all-white jury rules essentially, but also on Black testimony. That was a well-known phenomena in Illinois. I think that was true as well, but also throughout the South. So there's a lot of limitations. I mean, that goes through a lot of different amendments.
Yeah.
And so the change is, okay, well, what do we do to deal with that problem? Since now we know that states, can actually really eliminate, or not eliminate, but essentially limit those core freedoms, we need to apply the Bill of Rights to the states too. And that's how we get to the 14th Amendment.
Awesome. So let's just real quickly, before we dive into applying the Bill of Rights to the states, can we just look really quickly at some of the Bill of Rights and kind of how they exactly line up with the civil liberties? So like if you wanted to look at Second Amendment, for example, I want to look at Second, Fourth, Fifth, maybe Sixth. Can you give us kind of like real quickly a run through how's the Second Amendment connected to civil liberties directly for all of our students? Yeah,
so I mean, I think the best thing to think about is put right there, right? We're talking about the right to self-defense. Now, that actually, going that core protection will take us back to that whole discussion at the beginning of the natural liberty and kind of the essential basis of these ideas, these core liberties. Is that in the state of nature, you have a right to defend yourself in your home and your family. And that when creating governments through what we would call the social contract theory of the Enlightenment, you give away certain freedoms to the government to protect you, right? So the government can take on certain protections of you now, but you maintain some of that self-defense right. You don't give up the whole thing, right? And so that the Second Amendment is doing that. And then we could go into the discussion of the two parts of the Second Amendment, whether or not that's strictly individual or that's the community. But either way, it would take from this essential right that you can see, right, which is about self-defense. So it stems from there no matter how you look at it. The Fourth Amendment is the same thing, right? Is that essentially we could call it privacy, though that's just one 20th century theory of the Fourth Amendment. More essentially, it is the right is to one's home, to one's things, to one's personhood, right? However you want to put that, right? It's because there could be an autonomy theory, right? That would be a different way of thinking about it. But the point is, it comes from this notion that every individual has a certain space that is their own, and that can't be intruded upon without good reason, right? And that is, by the way, that's an essential way of stating the Fourth Amendment, right? Is, well, the government can intrude, but it needs a good reason to do so. The Fifth Amendment, we've talked about due process, but that's at the heart of a lot of the protections of criminal defendants in our system, which come in the Fifth and Sixth Amendments. So the Fifth Amendment protects, for instance, the right against self-incrimination. It also protects against double jeopardy. But in due process itself, which I mentioned, typically we think of protecting some sort of process in, for instance, a criminal procedure, although there's procedural and substantive due process. That's a whole wonky thing that takes a long time to get into, but it suffice to say is due process could mean something more too, which has to do with fundamental rights. That sounds messy, but the whole point is it goes back to the same set of propositions we started with. And the Sixth Amendment adds to those criminal protections, right? We're talking about the right to a jury trial, which I said was really considered one of those essential fundamental liberties by the founders, by that generation. That if you look in the Declaration of Independence, there are specific complaints listed against the British king and government of what fundamental liberties were violated. And one of them is the right to a jury trial, because under some of the actions of the British government, they could get rid of local juries and take colonists and bring them back to Britain to be tried before a British judge who was appointed by the king. And so they thought, well, that's an essential violation. So you need the right to a jury trial. There's the right to counsel that's within there. An impartial jury, which all this is to say is, it can't just be any jury, right? You can't poison the jury in some sense, right? You need more than just that. But all those types of things, right, that are put within the Sixth Amendment, which, again, those are those core rights of the criminal process.
So again, it's protecting individuals' liberty from the federal government. And that's what they're so worried about at that time. They're so worried about the federal government. So they put these civil liberties in there to ensure that your life pursuit of happiness is protected. Now things start to really shift after the Civil War. And what we see is that that life, liberty, and the pursuit of happiness, like you said in the Black Codes, are being affected by the state government. So the 14th Amendment is written, and that starts to lay out the groundwork for change, that those civil liberties in the Bill of Rights are now supposed to be protected for the individual, not just from the national government, but from any form of government, any layer of government. So I've got John Bingham here. Was that kind of his original idea behind it? This is what he was so worried about, is that, the state governments, the local governments were stepping on individual rights of many people, especially African-Americans with the Black Codes, but trying to take away their freedom to pursuit of happiness. It's clear, like, I want to get a job. I want to run my own company. I want to go into contract with somebody else. You can't do that under the Black Codes. They're stopping you if you're an African-American. So you have no way to pursue happiness. Yeah. And so was this really his biggest worry? And this is why he wrote this?
It's kind of a reminder too, that throughout this period, there was testimony, piles and piles of testimony given to Congress by Black Southerners through the Freedmen's Bureau principally, but they had all this testimony. So they knew the specific circumstances and incidents, right? So they knew exactly the thing. So it wasn't just kind of a broad thing of, oh, they're violating African-American liberty. It was specific. It was down to things like regulating laundries, in certain southern states. I once had a whole listing of these various. Some of it is just very, very specific, very asinine, and that gives you that sense, right? That it really was. You couldn't get the job you wanted, the business you wanted, those essential things you think that are very basic. Well, we're talking about those basic freedoms, right? And that Bingham is thinking you need a right to redress, right? Who's going to redress the problem? Because the states are showing no interest in redress. They're showing interest in actually clamping down on freedom as much as possible. So the federal government needs to be given the ability to deal with that problem that a lot of Bingham, personally, I always like to say is like Bingham thought the government could kind of already do that, but he was largely alone on that. And so an amendment was needed. The other thing we always mention, and I think it's worth saying here, is that they also acted before the 14th Amendment with the Civil Rights Act of 1866. I'm going to bring that up to say that we're talking about civil liberties. This is my point in saying that the language is shifting, but it's not quite there to where we think about in the 20th century. They're talking about civil rights as opposed to political, social, and then kind of the language of natural liberty or other things like that, right? And they lay out some of those specific rights in the Civil Rights Act of 1866. They're talking about property rights, contract rights, right to self-defense, things like that, right? They're listing them out and saying all those things we have testimony from. We know that the southern state governments are violating constantly. And so we're going to pass this act under the 13th Amendment, but we don't know if it's constitutional or not. So we need the 14th Amendment. So because we don't just need the act of Congress, we need to guarantee this going forward. That cannot be broken by the future acts of Congress, right? It needs to be entirely guaranteed and enforceable by the federal government, that other key part, right? Whether it's the courts or Congress, they need power to enforce those basic liberties through due process, privileges or immunities, and the equal protection of the laws, all those guarantees.
So the 14th Amendment is supposed to guarantee that the federal government will do something about it. Like now you have the power, you have everything you need to write a law to ensure equality under the laws and to ensure it. But it really doesn't happen that way. We get a big pushback and we get, almost a weakening of the 14th Amendment. And then when we talk about incorporation, I want to help explain to the students, what does the word incorporation mean? And it takes time and it takes people suing and fighting and bringing it to the Supreme Court to create what we call selective incorporation, which is like starting to make the Bill of Rights stick to people.
Piecemeal.
Piecemeal. Yeah, that's a good word for it. Like piecemeal, making the Bill of Rights be our tool, not just a tool to stop the federal government. So do you want to start, what case do you want to dive into this with? Here's a listing of some of the cases.
I think we should say, first we just give the quick beat on like why it took to the 20th century, because that problem is clearly asked by having this huge gap. We just talked about the for a minute. Hey, why did it take all this time? While we're not going to talk long about the cases because we do in so many other classes, but suffice to say, CRUIKSHANK's kind of the major case in 1876. Slaughterhouse is there too. But the real takeaway from that and civil rights cases, all these, is that the court is limiting the application of the 14th Amendment to the states through what we call the state action doctrine. The real point is they're saying if the state doesn't personally act, federal government can't do anything about civil liberties violations in the South. That's up to the state governments. They write criminal laws. Yes, there was a massacre in this case of over 100 African Americans in Louisiana, but we can't do anything about that. That relates to another case in which they struck down portions of the Civil Rights Acts of 1870 and 1871, also known as the Enforcement Acts, under similar logic. And so the point is there's a pushback, right? And that means that there's a period of time there. Too. It does come through the courts. The courts are a significant part of that pushback because they create the space for that later, in some sense, right, for the rise of the Jim Crow laws, not just because there isn't this enforcement of civil liberties, but also because the state action principle gives a suggestion, which is as long as it doesn't look like the state's doing something or it looks like a neutral principle, you can write certain laws that have an effect on the ground of limiting the freedoms of African Americans. So that's what takes us time to get to the 20th century and what we call selective incorporation. And yes, the question within there is why not just incorporate the whole thing? Well, that is, we always say that's what Justice Hugo Black said. There is competing theories of incorporation on the court. And Black said, well, no, we should incorporate everything or nothing. And he said that as early as 1947. But that's not what the court really did. They really did it piece by piece. And what we mean by that is not even a whole amendment, but parts of the amendment. So you look at Gitlow and we're saying the freedom of speech clause of the First Amendment is incorporated against the states. That doesn't mean the whole thing, right? There are separate cases for incorporating the Establishment Clause and the Free Exercise Clause against the states, for instance. And that's why you see Timms and Ramos on there, is because all the Bill of Rights actually are not incorporated against the states, or all portions of them. So Ramos,
yeah, look at those years, kids. That's pretty late.
Yeah, so Timms incorporated part of the Eighth Amendment against the states, which is to say some cruel and unusual punishment had already been incorporated, but a separate clause about excessive fines had not. So that's what happened there. And Ramos has to do with the guarantee of a right to an impartial jury trial, whether or not that includes a requirement of unanimity in a jury. And the reason is that in the 1970s, the Supreme Court has actually said the opposite, which is that states could have 10-2 juries or 11-1 juries, not non-unanimous juries. So they were arguing over this stuff in the 60s and 70s. Yeah.
Yeah. So just to kind of go,
it's a mess.
Go through this is incorporation means that the Bill of Rights is applied to the states as well. Yep. That it's not just the federal government can't step on your freedom of speech or needs to make sure you have a fair and impartial jury. It's now saying that the state governments, the police, kind of the local governments must be, but they didn't just blanket say, here's the Bill of Rights, everybody. It applies to everybody.
And I should include there, yeah, that the fundamental rights, it's actually the language that they use, is like the reason why they don't just do them all at once is they say, no, our question is this right fundamental or not? It's sort of a historic question, but it's kind of wishy-washy. You know, that's basically the court's analysis, is that fundamental or not. Ramos is pointing out they changed their minds. In 1972, wasn't fundamental. 2020, it is fundamental. But that's because that's selective, right? It's not the whole thing. It's piece by piece, which parts of the Bill of Rights were the most essential protections. That takes us to the Warren Court, so we can get a little bit of the actual. They're looking at it piece by piece.
Yeah, they're looking at it piece by piece, and they're going, is this a base right that you should get? Let's just check it and make sure. But this big kind of push and change really, really kind of hits overdrive with the Warren Court, right? This is why we pull out the Warren Court. So tell us a little bit about the Warren Court. We have 2 minutes. Fly us through.
Well, so, I mean, it's two things, right? We just talked about incorporation. So there's a lot of incorporation cases. I mean, the other things that's going on is that they are more freely defining civil liberties in a variety of cases. So when you talk about things like Gideon versus Wainwright and Miranda versus Arizona, we're not necessarily talking about incorporation cases, but we're talking about these major cases in terms of laying down significant civil liberties principles that we still rely upon, right? So Gideon, we can go back to Gideon, you can see Mr. Gideon himself, who was an aging criminal who was wrongly convicted of a crime, thrown into jail in Florida. He did not have good assistance of counsel. So in a time in prison, he taught himself the law. He, what we would call a jailhouse attorney, and then he filed an appeal 5 years later from prison in Florida. It was actually a writ of habeas corpus to make Kerry smile that eventually got to the Supreme Court. And so the principle out of Gideon is what we call the right to counsel. That the problem with what Florida did is that they had, under the Sixth Amendment, improperly taken away this fundamental protection of all criminal defendants to counsel. And this actually overruled a previous case, but the point is that this is for defendants who can't afford attorneys, they have a right to counsel. So when you hear that you have a right to an attorney, and if you cannot pay for one, the state will provide you, when you hear that in a police procedural show or Law and Order, that's Gideon versus Wainwright. And that's been expanded over time to include things like what assistance looks like, what your lawyer must tell you, what they must inform you of, what is good enough representation is essentially, right? Which is to say the Sixth Amendment also means if it's bad assistance of counsel, that's also a violation of your fundamental civil liberties. So Gideon gives us that. And then the other thing is Miranda. And we just talked about the warnings a little bit.
Tell us about, what do they hear? Yeah, what do they hear in the shows?
You have,
and then
you hear a right to remain silence, which, by the way, that's Fifth Amendment, right? So we should say there's a combination of Fifth and Sixth Amendment here. So Fifth Amendment, you have the right to remain silence. That's the self-incrimination, right? You have a right to attorney. Oh, we got the Sixth Amendment. Anything that you say can be used against you in a court of law. Again, that's self-incrimination. The reason you have a right to remain silent is because if you do start speaking, anything you say can be used against you. That has to do with interrogation, which gets us to Miranda, because the whole thing with Mr. Miranda is he spent 2 hours in police interrogation. He told them what they wanted to know. He was charged with the crime, and then he sued. And he is sued because they did not properly inform him of his rights when they decided to interrogate him. And so this is actually a 5-4 decision. So this is actually a close decision, but it is written by Earl Warren, who says, look, I mean, it was irregular, improper way of getting this evidence, so it's not admissible. And he looked at really decades of studies of how criminal defendants were treated going back to the 1930s and said, well, look, I mean, police still use physical force to obtain confessions. These tactics created an interrogation environment with no other purpose than to subjugate the individual to the will of his examiner, which was destructive to human dignity. It was trickery. It was psychological ploys. He says, so therefore, the person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent. There it is. And that anything he says will be used against him in court. He must clearly be informed that he has a right to counsel with a lawyer, and the lawyer can be with him during interrogation. And that if he is indigent, meaning if he cannot afford one, a lawyer will be appointed to represent him. That's all those classic things you hear when you hear those Miranda rights, or what we call the Miranda warning, which even was controversial after it's decided. Congress actually tried to push back against this and go back to the former standard. They weren't sure how this would work out in the real world, but that established this thing that police do routinely, came out of a court decision to give a better sense of what they thought these essential civil liberties meant.
And I think that's an awesome way to kind of wrap up this understanding.
There you go, the Wickersham Commission. That's the 1930s.
I know. I'm a little obsessed with Wickersham, and swear that's why the Wickersham brothers are important here too. I swear that's the reason why. But if we really understand, like Miranda, the Gideon, these more modern cases, even when we look into today, this idea that you have a right to be protected, to have a fair system, and what makes it fair? Being able to have support that you need when you're in this situation and understanding the law. And what I think is so fascinating about this case is, if you dive into Miranda, he's not a great person. Like
no. I didn't mention what he was charged with because
we don't have to talk about that.
I don't have to go into details, but he may have been guilty.
But it doesn't even. But the point is, and why they picked the case is because we look at the facts. And were you giving the right liberties to be able to make sure that you could have the right process?
And for future defendants, right? Because what the Supreme Court is doing, and this is an important thing just to say, right? For the Supreme Court doesn't just take individual cases and facts. It takes cases to pronounce principles going forward. And therefore, while Mr. Miranda probably was maybe guilty of some pretty terrible things, the fact that they violated his civil liberties in order to get the evidence to convict him, that was the problem. It wasn't what Mr. Miranda did. It was how they learned about it. And that couldn't be repeated, right?
And that, I love that understanding, Nick, that was great. Like, this is how we understand why they take these cases. And this is why to lay out kind of the formula and the plan and to make sure that these civil liberties are protected. And it doesn't matter who, it matters if it was protected or not. So we'll all look at these cases with that lens.
Bad facts make bad law. Remember
exactly.
that.
Keep the facts you don't need out of it. You don't have to look at them. Look at the facts of the case. What a great class on civil liberties. I hope you feel more liberated.
Okay. 35 minutes, not 40 minutes.
closer and better. Students, thank you so much for joining us in class today. I hope you had as much fun as we did. And we will see you next time in class. Have a great week. Have a great week.
All right. And I don't